Hi, it's Musharraf Hussain with the subject of interpreting taxing statutes. Our today's topic is judicial precedent. Judicial precedents comprise rulings pronounced by the judges in the court of law. Once it is assimilated, the judicial precedents become common law. A trial court that ascertains the facts in issue examines the evidence and decides the case by applying the law of the land to determine the rights and obligations of the litigating parties. It does not set any precedents. They take up question of facts and answer them only. A higher court that adjudicates upon the issues arising with respect to the meaning of law which has been doubted by the contestant and may impact the rights and obligation of the contesting parties sets the precedent. They take up questions of law and answer them. Here one should keep in mind that the courts are not legislatures who promulgate the law. Their role in respect of legislation is twofold only. One, to examine the validity of the act of parliament or the legislature through the touchstone of the constitution, and in case of delegated legislation through the touchstone of the act. And second, to interpret or ascertain as well as determine the meaning of the enactments through the canons of interpretation, allowing scope for a discretionary, pragmatic approach to the particular problems that come before the courts. Article 141 of the Constitution says that the law declared, that is, the interpretations made by the Supreme Court, is law of the land and is to be followed by all courts in India. But it is not that everything of such decision binds the inferior courts. It is the ratio decidendi, the reason for deciding, that is, the principle or rules on which a court's decision is founded, without which the case must have been decided otherwise. The Supreme Court, however, is not bound by its own precedent, though it ordinarily does not depart from its earlier rulings. Moreover, to overrule an extant ruling, the existing ruling, a bench larger than the bench which gave the ruling is considered appropriate. Obiter dictum. An obiter dictum, that is said by the way, is judicial utterances, remarks or opinions made incidentally or collaterally by way of illustration, argument, analogy or suggestions. It may be persuasive only. An obiter dictum of Supreme Court may be binding on the High Courts only in the absence of a direct pronouncement on that question elsewhere by the Supreme Court. But as far as the Supreme Court is concerned, it is not binding, but it does clearly have a persuasive authority, as held in the Oriental Insurance Company Limited versus Meena Varial, 2007, Volume 5, SSC, page 428. Estia decisis, and a Latin maxim again, to stand by the things decided, meaning in English. In Krishna Kumar versus Union of India, 1990, Volume 4, SSC, page number 207, it was held that a deliberate and solemn decision of court made after argument on question of law, fairly arising in the case and necessary to its determination, is an authority or binding precedent in the same court or in other courts of equal or lower rank in subsequent cases, where the point is again in controversy, unless there are occasions when departure is rendered necessary to vindicate plain and obvious principle of law and remedy continued injustice. It should be invariably applied and should not ordinarily be departed from where the decision is long standing and rights have been acquired under it. This estate decisis, or commonly called as the doctrine of precedent, mandates that an exposition of law may be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts, as held in State of UP versus Ajay Kumar Sharma 2016, volume 15, SCC, page 289. So a settled principle of law should not be unsettled, and in this way, this doctrine, the doctrine of estate decisis or doctrine of precedent, is wider than Article 141. Through the application of these principles, the law expounded by the High Court has got authoritative value and should be followed and applied even by coordinate or co-equal benches, and certainly by all smaller benches and subordinate courts, even though the Constitution does not contain provision equivalent to Article 141 in respect of High Courts. Judicial discipline. Doctrine of precedent should not be confused with the follow-up of the directives and decision of the High Court by a subordinate court because of the power of superintendence under Article 227. Example gratia, that is, for example, redeciding by a single judge bench of the issue in a particular place already decided by the division bench of the same High Court is wrong, as held in the State of UP versus Shionandan 1984, Supplementary SSC, page 190. Presidential value of third tier judicial body. District courts and courts subordinate thereto are trial courts or court of facts, and so their decision is binding to the litigant parties only. Similarly, decisions of the tribunal are not precedents because they are only binding between the litigating parties, even though it functions as a court of facts as well as of law, though it is referred for its persuasiveness. Advance rulings under taxing statutes are the legal opinions of the authority in respect of a particular provision and its application to particular assessee in the stated situation, and therefore is binding between the government and the party who sought it. A precedent loses its binding effect if a statute or a statutory rule inconsistent with it is subsequently enacted, or if it is reversed or overruled by a higher court. Reversal occurs when the same decision is taken on appeal and is reversed by the appellate court, whereas overruling occurs when the higher court declares in another case that the earlier case was wrongly decided and so is not to be followed. Precedents are distinguished when the demand of justice from the facts of the latter case is materially different from the prior decision. Prospective overruling, a judicial innovation. In Golaknath case, AIR 1967, Supreme Court, page 1643, it was laid down that the fundamental rights could not be taken away or abridged by the constitutional amendment. But it was added that this has to take effect for future amendments, not the amendments which has happened before. like the First Amendment, Fourth Amendment, and 17th Amendment. Because holding those previous precedents and those amendments as invalid from the previous date would have upset everything done so far in the agrarian field, that was the abolition of zamindari system, and would have created many complications, and therefore the apex court came with the doctrine of prospective overruling to salvage the situation. Per incurium, through lack of care or carelessness, we can say, a judicial decision that was rendered in ignorance of a statute or a statutory rule is per incurium and has no binding effect as a precedent. The rule applies even when the court knew of the statute in question, but had not taken notice of its precise terms or had not appreciated its relevance to the matter in hand. The mere fact that the court misconstrued a statute or ignored the rule of construction, not the rule, but the rule of construction, will not vitiate the binding force, however. Per incurium with respect to common law, similarly, whenever a relevant prior decision is not cited before the court or mentioned in the judgments and the court acted in ignorance or forgetfulness of it, then such decision is also termed as per incurium and is not binding on a later court. Sub silentio, literally meaning under silence. When the particular point of law, in the previous scene we have seen that it is per incurium when it is ignorance of a statute or a statute rule or of prior judgments. But in sub silentio, when the particular point of law involved in the decision was not consciously determined, that is, it was neither perceived by the court nor it was present to its mind, then the decision is said to be arrived at sub silentio. A famous precedent for this is Probanchal Cables and Conductors Private Limited versus Assam State Electricity Board 2012, Volume 7, SCC, page 462. Such decision is not binding on later decision with respect to that point of law, since it was decided without argument, without reference to the crucial words of rule, and without any citation of authority on that point, as has been quoted from Fitzgerald 2010, page 152 to 154, in DJ Malpani versus CCE 2019, volume 9, SCC, page 120. In limine, literally meaning at the threshold or at the outset. The dismissal of a special leave petition SLP in limine simply implies that the case before this court was not considered worthy of examination for a reason which may be other than the merits of the case. Such in limine dismissal at the threshold without giving any detailed reason does not constitute any declaration of law or a binding precedent under Article 141 of the Constitution, as held in the State of Orissa versus Dhirendra Sundar Das 2019, Volume 6, SCC 2000, page 270. Thank you.